Hello everyone. So today we'll be learning about the sales of Goods Act 1930, and this is my second video on the sales of Goods Act 1930. So if you have not watched the previous video of the sales of Goods Act part 1, then please kindly watch the video of sales of Goods Act part 1, and then you will be able to follow follow this video. The topics and the contents of this video would be basically the conditions and the warranties. So we'll be studying today about the conditions and warranties. So let's begin then. So these are the contents which we will be studying today. So we will be doing basically the meaning of conditions and warranties, the difference between conditions and warranties, express conditions and implied conditions and warranties. Fine. Now let's start with the meaning of conditions and warranties. Basically, before starting with conditions and warranties, we should understand that what's the meaning of stipulation. Basically, stipulation means that any kind of terms and conditions which are there and which need to be fulfilled first, and thereafter the ownership of the goods can be transferred, that is called stipulation. And stipulation may be in the form of condition or a warranty. A condition means and a condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to the right to treat the contract as repudiated. It's been defined under section 12, subsection 2. Warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not a right to reject the goods and treat the contract as repudiated. It's defined under section 12, subsection 3. So now let's understand conditions and warranties with the help of the differences. Condition is a stipulation that is essential to the main purpose, and condition cannot be avoided while implementing the contract of sale. Whereas the warranty is a stipulation collateral or supplementary to the main purpose. And if there is a breach of a warranty, means it is also important but not much essential. Now, when there will be a breach of condition in a contract, basically it will lead to the repudiation of the agreement or a contract. A contract of sale can be avoided if the condition is not fulfilled. So condition is must, it should be fulfilled. And warranty is only a right to sue for damages. Therefore, in a breach of warranty, contract of sale cannot be set aside. Only the aggrieved party shall claim for damages. A breach of condition may be treated as a breach of warranty under certain circumstances which are given under section 13. It depends upon the intention and the will of the parties as to whether to treat the breach of condition as a breach of warranty. And in case of warranty, a breach of warranty can never be considered as a breach of condition. And the contract cannot be set aside if there is a breach of warranty. Now we'll be learning about the cases under which a condition may be treated as a warranty. Where a condition of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition. So first case is by waiver it is possible. So the buyer may waive means he may give up his right upon the seller to get the conditions fulfilled. He may ask the seller that he no more wants that the condition be fulfilled. He still be continuing with the contract and he'll be accepting the goods, even though the condition has not been fulfilled by the seller, which was previously agreed between the parties. So by waiver, it is possible, and buyer has a right to do so. So first case is by waiver, condition may be treated as a warranty. Next one is by election it is possible. So when there is a breach of condition and the buyer still want to continue with the contract and do not want to cancel it and still want to accept the goods, he may do so by electing the breach of condition as a breach of warranty. Next case, that is the third case, in which suppose the goods are not severable and the buyer has accepted those goods or entirely or in part, then the breach of condition may be treated as a breach of warranty. Let's take one example. Suppose the parts of car are coming from Germany and our buyer is an Indian buyer, so he'll be taking the parts from the German exporter and he'll be assembling in India and then he'll be selling the cars. Here, what happened? That the half of the parts of the car have arrived. With the buyer, and next consignment is due. At the time of next consignment, basically a breach of condition took place. Now, if a breach of condition takes place, we understand that the contract can be repudiated or cancelled by the buyer. But here, the half of the parts are with the buyer, and obviously, if at this point of time, if he cancels the contract, he will be at much more loss. So obviously, buyer may choose that he will be taking all the parts from the seller, and therefore he'll still be continuing with the contract. So he will be asking the seller to send all the parts, and obviously he'll be treating this breach of condition as a breach of warranty. He may claim some damages from the seller and still continue with the contract. So this was the third case which was explained. Now the fourth case. In the fourth case, the condition is excused by law by reason of impossibility. This means that suppose there is an amendment in the Act itself, that is the Sales of Goods Act, and previously six conditions are there. We are talking about the implied conditions. So six conditions are there in the Act which need to be fulfilled. But here, after the amendment, only the five conditions are left. The last condition was repealed or cancelled by amendment. So what will happen that if the last condition which was being cancelled or I would say repealed, if it get breached also, then the contract will not be set aside. Fine. So these are the four cases under which the condition may be treated as a warranty. Now we'll learn about the expressed conditions and warranties versus implied conditions and warranties. So conditions and warranties basically may be in a form of expressed or implied. Now let's understand first the express conditions and warranties. The express condition and warranties are those conditions and warranties that are specifically expressly agreed between the parties at the time of contract of sale. Implied conditions and warranties means those conditions and warranties that are incorporated by law. Law means here Sales of Goods Act into the contract. So implied conditions and warranties are given by law. So we will be studying about the implied conditions and warranties in the Act further. And it is these implied conditions and warranty may not be specifically even not given in the contract itself. Then also it has to be fulfilled because it is given by law. And all the contracts which are entered into the boundaries of our country, that is where the Sales of Goods Act is applicable. Our Sales of Goods Act is applicable to the whole of India. So wherever the contract of sale is being executed, then the implied conditions which are listed in the Act shall be fulfilled by the parties. But if the parties agree or stipulate to the contrary, this means that if the parties want to do not want to fulfill a condition which is an implied condition given by law, they can do so, but they have to first mention that condition in the contract expressly and have to say that this condition is given by law, but in our case it is not applicable, or both the parties have given the consent that if they will not be fulfilling this condition in the present contract. So this way a condition of implied condition can be avoided, can be avoided. But otherwise in other cases, whether expressly mentioned or not, these implied conditions and warranties must be fulfilled when a contract of sale is executed or entered between the parties. Now, these are the 6 implied conditions which are given by the Sales of Goods Act. First one is condition as to title. The next one is conditions in the sale by sample. Third one, condition as to quality or fitness. Fourth one, merchantable quality. Fifth one, condition implied by usage and custom. Sixth one, condition by sample. Now let's understand the first condition, that is condition as to title. Title means ownership. In case of sale, the seller is the owner and the goods are specific goods and the existing goods. So therefore, the seller has a right to transfer the ownership from the first day. And in case of agreement to sell, the subject matter of agreement to sell are future goods and contingent goods. So obviously, these goods first need to be acquired or manufactured by the seller himself. Then only he will be able to pass the property or pass the ownership of the goods. In the case of Ronald versus Duval, R bought a car from D and used it for 4 months. D had no title to the car, and consequently, R had to hand it over the car to the true owner. Held that the R could recover the price paid from D, provided D is traceable. Here, from the case study, we can understand that a non-owner or a person who has no right to transfer the ownership, if he transfers the ownership, then he will be transferring the defective title and not the valid title. So when R received the car from D, obviously the title of the car which D had was a defective title. He was not the owner, or he didn't have the authority of the owner to sell the car on behalf of the owner. So therefore, he is considered to having a defective title. So he had transferred the defective title, and when the true owner has found out that the car is with R, so obviously court will decide that the true owner will get back his property. And R faced the loss, so the loss will be with respect to the price which he had paid to D shall be recovered from D, provided D is traceable, right? Condition as to description. In case of sale by description, there is an implied condition that the goods shall correspond with the description. This means that the description and the goods which are supplied should match. If the contract is made to sell peas, then the buyer is not obliged to take beans instead of peas. And because the article which is being tendered, if it is different in any respect, then the buyer has no obligation to take it. This was decided in the case of Bose versus Shand. In this example, A wants to sell his PC. He says B, the intending buyer, who has not have seen the machine, but that the brand new machine will be sold to him. B agreed to take that machine, and on delivery it was found that the machine was old and repaired. So here the description and the product is not matching. Therefore, B can repudiate the contract since the condition is breached. Condition as to quality and fitness. Normally, in a contract of sale, there is an implied condition that the goods which are being given, the goods must be of a proper quality, and the quality and the fitness for the purpose will be checked by the buyer. So, buyer must examine those goods thoroughly before he buys them, and he must satisfy himself about those goods, that whether these goods will be useful to him, it is a better quality good, and it is fitting the purpose or meeting the purpose for which he is buying. So it's buyer's basically the duty to check the quality and the fitness of the goods before buying. And if later on buyer found that the goods are not suitable for the purpose for which he had purchased, the seller cannot be asked by the buyer to compensate for the same. So seller shall not be responsible. to compensate the buyer if the buyer makes a wrong choice. Exceptions with respect to the rule of contract as to quality and fitness. Here, if the three conditions which are mentioned here, if these conditions are fulfilled, then the seller shall be held responsible and he has to compensate the buyer. The purpose for which the goods are purchased, if it is clearly expressed to the seller or is communicated to the seller, and seller knows the purpose for which the goods are being bought, then he must give the goods which meet the purpose. The buyer must have relied on the seller's knowledge, skill, and judgment. So buyer is trusting the seller and he is taking the opinion of the seller before he buys. Then obviously the seller should give the best opinion or best knowledge should be shared. The selling of such goods must be a part of the normal business of the seller. So seller is a quite experienced seller and because he is selling those goods as a normal business activity. So if these three conditions meet, then the seller will be responsible for not giving the good quality goods or not giving the good product which is not meeting the purpose. In this case, priest versus last, a man bought a hot water bottle from the chemist, which got burst and it injured the wife of the person. It was held that the chemist had committed a breach of condition as to fitness of the bottle. In this case, the person, the buyer, relied on the knowledge and the skill of the chemist, who is knowledgeable to give him the better bottle because the selling of hot water bottle was a normal business of the seller. So here the seller will be held liable because all the exception conditions are meeting and buyer will be getting the compensation from the seller. Condition as to merchantability, where the goods are bought by description from a seller who deals in those goods of that description, there is an implied condition that the goods are of merchantable quality. Merchantable quality mean that the goods are commercially sellable as per the description by which they are known in the market at their full value. This means that the goods should be commercially sellable, or if the buyer wants to resell those goods, he must get the full value of those goods. The intention of this condition or the section is that that in the market the goods which are unfit goods or which are unsellable quality goods should not be sold and should not be traded. The goods which fail to perform the function for which they are produced should not be traded in the market. If a pen which cannot write properly, a watch which cannot keep time, or a camera that cannot shoot properly shall be regarded as the products which are lacking the merchantable quality, and therefore it should not be traded in the market. In the case of Jones versus Just, there were two merchants, one from Liverpool, another from London. They were actually dealing in the goods, that is, the Manila hemp. Manila is a place, it's a capital of Philippines. It's a Southeast Asian country, a small island country. And hemp is a seafood. So basically, hemp was being traded. And the hemp reached the Singapore port, the destination. When it reached the Singapore port, but hemp were utterly damaged by seawater. The container of hemp, in the hemp's container, the seawater seeped in, and obviously the seawater is salty, so that's why the seafood got spoiled or rotten. And obviously, it was held that these goods are not of a merchantable quality because the buyer, if he takes those goods, and he will not be able to find any other buyer, and obviously he will not be able to sell those, make a sale of those goods in the market and get the full value of it. So these goods are no more commercially sellable or merchantable, and that's why the goods were rejected and the contract was cancelled. Condition implied by usage and custom or we can say the condition of wholesomeness. In case of eatables and the provisionary items, the consumable items, one more condition is there, that is the condition of wholesomeness. The goods must be wholesome in nature. This means that the goods should contain the nutrients which will help the body, and not the goods which are adulterated and containing the things which are harmful to the body. So here what happened in case of in this case, X purchased milk from Y, a milk dealer. A milk contained typhoid germs, and after consumption, X's wife, after taking the milk, got infected and died. It was held that the X will be entitled for damages. So he may get the damages from the seller. Condition as to sample. Condition as to sample. In this condition, what happens? Suppose in a contract of sale, it is agreed that first the sample is shown and then the bulk or the order will be placed. So here we can understand that in case of sale by sample, the following implied conditions must be fulfilled. The first one, the bulk shall correspond with the sample. So all the goods, suppose 100 goods are ordered, 100 units of goods are ordered, then all the 100 units should be matching with the sample and as per the quality. The buyer shall get a reasonable opportunity to compare the bulk with the sample. So buyer has the opportunity to compare the bulk and the sample. So each product will be verified and will be checked by the buyer. And the goods shall be free from any defects, rendering them unmerchantable, that would not be apparent from the reasonable examination of the sample. So when the examination of sample and the bulk will be done by the buyer, all the goods should be free from any defects which make them unmerchantable or not commercially sellable. In this case, certain shoes were sold by sample for the French army. The shoes were found to contain paper not discovered by ordinary inspection. So the sole was not, obviously, when a person, when the sample and the bulk will be compared, the product will not be getting, they will not tear the shoe and will see that what is there inside the shoe. So obviously, during the ordinary inspection, it was not found that the goods were containing the paper instead of leather or rubber or other material which is required to make the shoes. So therefore, it is a case of fraud here. So it was held that the buyer is entitled to get the refund of the price, and also the buyer can claim the damages from the seller. Now we'll learn about the implied warranties. There are four implied warranties: quiet enjoyment or possession, freedom from encumbrances, usage of trade, dangerous nature. Warranty of quiet possession. In a contract of sale, unless there is any contrary intention, there is an implied warranty that the buyer shall have and enjoy the quiet possession of the goods. This means that the buyer has a jus in rem, a right that he can use the goods against the whole world, including the seller, and no one can dictate him the terms of usage after the ownership is transferred to him. And if the buyer is anyway disturbed in the enjoyment of the goods due to the seller's defective title, then obviously buyer can sue the seller for damages. Warranty of freedom from encumbrances. Basically, this warranty focuses on the sale of goods which are free goods and not encumbered one. How the goods can be encumbered? Let's understand that. Encumbrances means hurdle or obstacle in the transfer of ownership. So, if the goods are pledged by the seller and against those goods a loan is taken, obviously the goods are of a movable property, a floating charge is created on those goods. And this floating charge means that the goods can be still tradable, but the lender must be getting the periodic stock statements and the profit statements from the borrower, that is our seller. And the goods can be traded by the seller. So here before the sale takes place between the buyer and the seller, so buyer must have the knowledge about it, that whether these goods are free goods or the encumbered goods. And if the goods are encumbered one, then it's buyer's choice whether he want to take those goods or want to discontinue with the contract of sale, or should I would say that he may back out also from the contract of sale. He will not enter into those the contract of those goods, or contract of sale of those goods. So it's buyer's choice whether to take the encumbered goods or not. But it's the seller's responsibility to inform the buyer that any third party, that is the lender, has a charge over those goods. And after the buyer getting informed, it's his choice whether to continue with the contract or want to back out of the contract. He can do it. When the goods are encumbered goods and not the free goods which are being transferred, this warranty shall not be operative. This means that the warranty speaks about the freedom from encumbrances, means the goods which will be traded must be free goods and not the encumbered one. Warranty as to quality or fitness by usage of trade. Usage of trade means that those goods will be traded in the market which is able to perform the function for which they are being purchased. So if the purpose for which the goods are purchased cannot be fulfilled by using those goods, then the goods will not be taken by the buyer. So the product should confirm the purpose for which the it is being purchased. Warranty to disclose the dangerous nature of goods. Where a person sells goods knowing that the goods are inherently dangerous or they are likely to be dangerous to the buyer, and that the buyer is ignorant of the danger, he must warn the buyer of the probable danger. Otherwise, he will be liable to pay the damages. This means that whenever the goods are inherently dangerous, or some danger may happen if the goods are used in some other way, then the warning should be there from the seller to the buyer. And how the seller will inform the buyer? It will be written in the package itself, where we find, suppose in the example of cigarette packets, we find the warnings are written like cigarette kills, it causes cancer. They also give the pictures of the people who are suffering from cancer. So why they give it? This is a warnings message given from the seller to the buyer, that if it is consumed, if this product is consumed, it is harmful for the buyer. And after the warning is displayed, the seller work is done. And even after the warning is being written and the buyer has seen the warning and he still consumes cigarette and he dies, then the seller will not be liable to compensate the buyer. Seller's duty was to just inform the dangerous nature and disclose it to the buyer. And now it's buyer's choice whether he want to consume or want not to consume those goods. But if the seller is not informing the buyer about the dangerous nature and some mishap occur, then obviously seller will be held liable and he has to pay the compensation to the buyer. That comes to an end of today's session. So, hope you have understood everything with respect to conditions and warranties. So, thank you for your patient listening.